All right, you're charged with a terroristic threat of a public servant or placing the public in fear of serious bodily injury as a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to the $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
I do.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
I do.
Did you intend to give up those rights and enter into a plea in this case?
I do.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine?
I understand.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Allen, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No,
Anyone promised you anything other than the plea?
no, Your Honor.
Are you satisfied with the way you've been represented?
Yes, I have.
Are you a U.S. citizen? I'm sorry, not a U.S. citizen. That's not allowed to be asked anymore. Did you understand by entering in this plea, you could, if you're not a citizen, you could be deported, not allowed to re-enter the United States or denied naturalization? Did you understand?
I do.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
I did.
According to the plea, punishment is to be assessed at 3 years in the prison. There's a $2,000 fine. State is silent on your application for deferred adjudication. The state recommends community supervision. Did you understand that to be the plea?
I do.
Defense?
Yes, that's true.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
I did.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
I do understand.
And counsel, I believe we had any pretrial motions?
We did have some pre-trial motions previously in this case, and they've been disposed of.
All right. Outside the agreement, the state is recommending that your community supervision be for a term of 5 years. There'll be a TAP evaluation, 200 hours community service restitution, no contact with Charles Ireland or Mark Metley. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
I understand.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Yes, Your Honor. State tenders what has been marked States Exhibit 1 and all attachments.
All right. Did you review any objections?
I have no objections to those
Oh.
pieces, Judge.
Mr. Allen, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
I did, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent?
I understand.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
I did.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence States Exhibits 1 and attachments. Court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
Yes, Judge.
All right. Anything you wish to say on behalf of your client?
Yes, Judge. Last night, I electronically filed a sentencing memorandum. I think it's been accepted by the court, and I wanted to provide it to you along with the attachments.
All right. Any objections to the court reviewing the? Okay. All right. Yes.
And so, Judge, as you can see, essentially what primary reason and the desire for Mr. Allen is that he be able to continue with supervised access to his son, Aiden. As you can see in the attachments there, the civil trial court did understand that Mr. Allen would have supervised access to his son, both in San Antonio as well as North Texas. Additionally, we do know that on the 22nd, we received a letter from Thomas Villalobos, an update letter regarding bond conditions. That letter also attached had the Center for Healthcare Services finding that they had met with Ronald Allen to complete an intake for mental health services, and that he hadn't met criteria for qualifying mental health diagnoses at that time. The largest thing that matters the most to Mr. Allen and his family is that his GPS permit him to be monitored. That's fine if that's what the court desires, but he would like to be able to move freely about the state, to be able to see his son from time to time, attend his father's services, and help his mother maintain his father's properties. And so that is the primary thing. We totally agree with no contact with either Michael Ireland or Mark Medley. That's new to me, but he's fine not staying away from that man too.
Based upon the judge's notes that you presented to the court, those are people that are listed under the protective order. And there's a third person, it appears, well, there are two other people. It appears to be either this is Gallegos, and then they have Ramirez, and Ramirez is listed as the amicus attorney.
Okay, Judge, those are not, those are other litigants that were also in the judge's notes. Ms. Gallegos is actually here in the court, and she's the custody lawyer for Mr. Allen.
I'm just saying, the judge's notes that you gave me, they have these people listed underneath protective order.
Judge, I don't think that's accurate at all. I think that's being misread right now because
I mean, that's the only way I can read it and the reason why I'm saying that's the only way I can read it is because it lists Medley, it says protective order, and then indented right underneath, it says M. Medley, which is the state has outside the agreement. They're asking for a no contact order with that person, with Charles Ireland. And then they have someone by the name of Gallegos and Ramirez.
right.
And then right after it says that it has protective order, then right after it mentions those three names, then again, it says 2-year protective order granted as to, I believe that's the mother.
That's the mother's name. Yes, Mrs.
So-
Allen. Yes. But there is no protective order granted in that order regarding Mark Medley, regarding any of those people. The only one that has a protective order granted against is the mother of the child that we're talking about here. Ms. Gallegos is here and she hasn't asked for a protective order, and we know that the amicus doesn't have a protective order either.
Okay, so this is what I'm going to do. I've taken your plea, and if somebody can tender to the court whatever the orders are on the civil side, I'll review those, because those judges' notes that were handed to me appear that there's a no contact order. And I think you want to have those,
Right, exactly.
know for sure whether it is or not, because otherwise you may be violating orders over there.
Absolutely, absolutely, black and white.
So what we're going to do is, I've taken your plea. If you all are waiving PSI, I won't set it for a PSI. We'll just come back. When I'm back, I'm going to be gone the first week of September because I have to go to a judicial conference, have to keep up my educational courses. And then the second week I have jury duty, and I can't have other people go to jury duty and sacrifice their work, but I'm not willing to do the same. So I have jury duty that week. So it'll have to be the third week in September, and that'll give everybody a chance, and perhaps a chance for you to speak with the state with regards to all the names that they have listed outside the agreement, because they have Medley listed as a no contact person too.
Well, and absolutely. And we understand that Mr. Medley called and asked for that kind of to be added to this order. That's my understanding from my discussions and my review of the state's file. But, I think the reason you see this line that says protective order plus merits is because that is what the topic of the entire, and what you're seeing here is actually the litigants that are, or the attorneys representing each of these litigants.
The best way to discover what that means is
Judge. Yes.
the judge.
I just have one request. We have services from my father September 5th, and I'm on the
Go to the
GPS.
services.
Yes, thank you.
Yes.
Absolutely.
But here's the thing about going to those services and state, I've overstepped my bounds. Do you have any objections to his going to his father's services? All right. So what your attorney will need to do is I will print here a page with an order and I will do the style and you all need to write down your agreement.
Okay,
Okay.
All right?
absolutely. Thank you.
So you're welcome. So Ms. Ferguson?
Yeah.
When can we bring this back? And when it come back, I will need specifically what the judge is saying on the civil side
Yes.
so that this could a little bit be in harmony.
Absolutely, I agree.
I can do the 16th.
All right, the 16th, is that enough time for you counsel to have everything ready?
Yes, of course, Judge. And I want you to know that the civil court is waiting for the outcome of this case
All right.
in order to make their orders, and that's one of the reasons Ms. Gallegos is here.
All right, Ms. Gallegos, if we can go off the record, Ms. Gallegos, if you'll come up. All right. Hello, how are you doing?
Yeah, good. How are you?
Good seeing you.
Good to see you.
So anyway, it appears the documentation that I've received that has the judge's notes,
Mhm.
the way it's written, it appears that you're a part of the protective order. Metley is a part of the protective order. So if the court can get clarification from the judge
Okay.
on that side about who is really included in the protective order and what they are doing with the visitation, that will be greatly appreciated.
Okay, we have a conference call next week, and then we will be looking to get it entered. We are hoping to obviously do it as soon as possible, and we will try to meet your deadline of the 16th. And I'll let the other attorneys know. If not, do we need to send an email to Ms. Ferguson?
No, I mean,
Okay.
so I'll just need that information before the 16th. So if you all can get the judge to, if you all want to, you can have the judge email me and
Okay.
say, this is who's a part of the protective order. Or if there's a document, can you pass me that sheet of paper? Or if there's a document that tells me, this is the part of protective order, because the way the judge's notes are written,
Mhm.
it's so,
Okay.
oh, you know what? I'm sorry. I need to add this.
So normally on the civil side, Mr. Medley is first because he's
Mhm.
the petitioner. Margaret Gallegos, me, I represented the respondent,
Mhm.
and then Anna Ramirez was the amicus.
Yeah, no,
And then it goes
But
down.
the reason why I say that is
Mhm.
because in the plea bargain agreement, even though it's outside their plea bargain agreement, Medley is mentioned. I'm sorry, can I have that print out one more time?
Oh, I don't-
So that's why I
Okay,
need clarification, because the way that's written in the judge's notes, as you can see, it has a title protective order. Then it has a list of 3 people. Then underneath that list, then it comes back with a 2-year protective order. So it seems as though those are the people that he has a protective order against. So I would prefer that he know, I would prefer that I know, and probation knows.
so on here it says 2-year protective order granted as to Mrs. Allen.
But above it, it says protective order. Then-
Okay.
So if you all will fill in the dates for him, please, and what you all have agreed on as far as his ability to go to his father's services. So that sheet of paper, if you can just put in the agreed times where he can travel for his father's services.
Okay, I'll do that now.
All right, and if you all will confirm that, and then we will come back. Norma, you said the 16th?
Yes, ma'am.
All right, so we'll come back on September 16th, and at that time, I will enter my order. And we're back on the record, Cindy. And counsel, it's the court's understanding you're waiving PSI and TAP evaluation.
I would.
All right, so thank you.
Thank you, Judge.
All right,
Thank you.
Thank you.
Thank you so much. I appreciate it.
And thank you for dressing appropriately for.
Absolutely,
All
absolutely,
right, and you're not excused until you sign the reset form, okay?
absolutely.
Thank you, Judge.
All right, thank you. This is for sentencing, correct?
Yes, Judge. We were here previously, and there was some ambiguity regarding a protective order that had not been entered
Mhm.
with the civil court. And I have a copy of that protective order. Ask that Tiffany Allen
All right, Steve, have you had a chance to review that?
copy as well.
All right, so the court is calling 2025 CR 007563, State versus Ronald Lamar Allen. Can I have parties announced for the record?
Carl W. Richard for the accused.
And you are Mr. Allen? All right, so you entered a plea. Both parties agreed to waive the PSI report. According to the plea, the state was silent on your application for deferred adjudication. the court did request from the state. Does he have any other priors? All right. So, court understands that sometimes custody issues, divorce issues can be very chaotic and emotional. What I'm going to tell you, Mr. Allen, is I can grant your application for deferred adjudication. And I've told you this before, but I want you to internalize what I'm saying. If for some reason I grant your application for deferred adjudication and a motion to revoke were filed, if everything were determined to be true, you could potentially go to prison for 10 years. If I were not to grant your application for deferred adjudication and follow the state's request that your punishment be assessed at 3 years with a length of 5 years, if for any reason a motion to revoke were filed, you would be limited to 3 years in the prison. So this is up to you. Do you want deferred adjudication or do you want a felony conviction?
Deferred.
All right, so I'm going to grant his application for deferred adjudication. The deferred adjudication is going to be for 5 years. There's going to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days, no employment as a home health care provider or with minors. There's going to be 200 hours of community supervision restitution. I'm going to order parenting classes. Once that's completed, the court will deem the community service hours satisfied. Now, with regards to the no contact order. So states you've requested a no contact with Charles Ireland, and I believe that's his former attorney.
Yes, Judge.
All right, so there will be a no contact order with Charles Ireland. If your attorney has any type of paperwork or documents and you wish to have those documents, you'll need to have your new attorney reach out to them to obtain those documents. You're not to make contact with that attorney. You're not to go to that attorney's office. Do you understand?
Absolutely.
And then Mark Metley, who is Mark Metley?
He is the attorney of the Tiffany Allen. So we had discussed, Judge, that we had originally asked for no contact order. However, in the PO itself, it asked that Mr. Medley be the broker between communication. So we would just ask that this side of the court, if they're willing with order, no harmful or injurious contact.
What I'm going to order is there's to be no contact with Tiffany Allen or Mark Metley outside of legal communications. So your contact with Tiffany Allen is to be through her attorney and no one else. Do you understand?
Absolutely.
So, and I'm sorry, let me change that. And the reason why I say no contact with Tiffany Allen outside of legal contact is because if you have a court hearing and it's on the civil side, I'm sure she's going to be there.
Right.
So if it's your contact with Tiffany Allen can only be with court hearings or mediations. Do you understand? So there's to be no contact with Tiffany Allen outside of legal hearings. And for the court, legal hearings mean court hearings, mediations. And then there is to be no contact with Mark Metley outside of legal hearings as well. So with Mark Metley, you can email him as long as it's for legal reasons. You understand?
Right, but yeah.
Okay. Now, is there any other no contact orders that's being requested?
Right. So his communication with Tiffany Allen is limited to
Through his attorney?
either
I'm
through
sorry.
the attorney, and they have a co-parenting app that they use.
Yes, either through his attorney or through Mark Metley or in court. And then State, do you have any objections to him having contact with her through the app,
No, Your Honor.
through the parenting app? Okay, and I'll add probation, and also he can contact her through the parenting app. And are you in Bear County?
Yes.
There's going to be field visits one time per month until further notice. And there is going to be anger management. Probation, is there anything else? State, is there anything else? All right, and there will be a $2,000 fine, and that will be probated. Is there anything else you need from the court in order to be successful?
No, ma'am.
Counsel?
Judge, one question for me. Will Mr. Allen be free to move about the state in light of these home visits? Because they do have a property in Rockport, and he does have an upcoming funeral services that we handed to a quarter.
Well, with regards to funeral services, as previously stated, and I believe I signed an order, he's allowed to go to funeral services. But outside of that, if he's planning on leaving the county, he'll need to request that from probation, and I'll review it and see if it's appropriate. And just confer with the state on anything that is unrelated to his going to the funeral service, which I've already ruled upon. All right, did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it?
Yes.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, sir.
All right, we can go off the record. So here on out, everything that you do, you need to ask yourself, could this potentially result in me going to prison for 10 years? If the answer is yes, don't do it. If the answer is maybe, don't do it. If you have a question about a condition and you're unsure whether or not you're going to be violating it, pick up the phone and call your probation officer, okay?
I'm wearing a GPS monitor. When does that not take effect? I mean,
What will end up happening with regards to your GPS monitor? I'm going to see how you do on that. Probation with the GPS monitor. State, do you still want him on GPS?
Your Honor, my understanding he's had no violations up to this point, so I would defer to the court.
Probation, do you want him to continue on GPS?
But being that there's no violation, no.
All right, so this is what the court is going to order. The court will order removal of the GPS by Friday. You'll need to notify all the persons who have the no contact order that the GPS is going to be removed on Friday. And if there's a violation, then it's not going to be removed. You understand?
yes, sir.
All right, thank you.
Judge, I'm sorry, I have one last thing.
Yes.
We did previously sign an order regarding funeral services on September 30th. The client has informed me, and his family has informed me, that there's a typo in that. And I've conferred with the state. I filed a motion to amend the agreed order, and the state agrees that we can change that from the 30th to the 20th.
All right.
Thank you. Thank you, Judge.
And you need to give a copy of that to probation.
I will.
All right, is there anything else?
No, Your Honor. Thank you.
All right,
very
thank
much.
you.
Thank you, Judge.
You're welcome.